Good evening, students. I hope I'm audible. Yesterday, we have talked about the social transformation and women and social transformation in context with the child. Today, we are moving ahead with the modernization and the law. Basically, we are going to focus firstly upon the fundamental duties, how it has the impact of the modernization on the fundamental duties. We are slightly going to refer the family laws. Then we'll be referring to the reforms specifically in connection with the agriculture. Then we have the environmental protection and industrialization, and outcome is of the sustainable development. And then lastly, we'll be moving to the reforms of the court processes, which includes the ADR, which includes the Lok Adalat conciliation, and to some extent the prison reforms and the other decentralization process. So this is the agenda for our today's session. Let us move ahead with the fundamental duties. Specifically, when we talk about the fundamental duties, we know that fundamental duties are that part where we have focused. You already have studied the fundamental duties in your constitutional law paper. But now we have to focus and we have to see that what kind of the fundamental duties in modern context have been implemented so far. So if you try, hope the screen is visible to you, you know that there's always a concept of the rights and duties. So basically, when you have the rights at the same time, you must have the duties. And so they're correlatives and inseparable from each other. And so that's why this is how we talk about the fundamental duties. We also know that fundamental duties are when we talk about the original constitution, fundamental rights and duties of the state were there, but not the fundamental duties. And in 1976, we have the fundamental duties added, and we also have an addition in 2002, which is inspired by the constitution of the erstwhile USSR. Then the Japanese constitution is also having the reference to the rights and duties concept. Okay, so it is not just that we have included as as a part of constitution, but we can find this particular element in most of the nations as well. Again, we know that these fundamental duties being the part of the constitution by the recommendation of Swan Singh Committee, 1976, the Congress Party set up Sardar Swaran Singh Committee, and so there was a need and necessity failed during operation. So there was a need and necessity failed during the operation of the internal emergency 1975 to 77, and so that's why the separate chapter is recommended by the respective committee. So citizens should become conscious that in addition to the enjoyment of the rights, they also have certain duties to perform. And so the government accepted the recommendations by 42nd Constitutional Amendment Act 76. And so Part 4A inserted with effect from 51A the fundamental duties. The one more addition was there by 86th Amendment 2002, and then we have Article 51A. So all these things you already have studied so far, and you already have done what is Article 51A. So basically, to abide by the Constitution and respect its ideals and the institutions, the national flag and the national anthem, to cherish and follow the noble ideals which inspired our national struggle for freedom, to uphold and protect the sovereignty, unity, and integrity of India, to defend the country and render the national services and when call upon. You can have the reference of the Ukraine currently going on, the most of the civilians, most of the citizens of the Ukraine now being the part of the forces in the Ukraine. So this is basically to defend the country and render the national service when called upon to do so is a fundamental duty of an individual. And so, to promote the harmony and the spirit of common brotherhood amongst all the people of India, transcending the religious, linguistic, and regional sectional diversities, to to renounce practices derogatory to the dignity of women. Yesterday, we have referred this particular element. And so that's why these are some of the elements that we must have to understand. So to value and preserve the rich heritage of our composite culture, to protect and improve the natural environment, including the forests, lakes, rivers, wildlife, and to have the compassion for the living creature. So in modernization, we said that we are going to have the reference of environmental law, and so this is one of the fundamental duty that we can have the connection. Then we have to develop the scientific temper, the humanism, and the spirit of inquiry and the reforms to safeguard the public property and to abjure the violence, to strive towards the excellence in all spheres of the individual and collective activity, so that the nation constantly rises to higher levels of endeavor and the achievement, and who is a parent or guardian to provide the opportunities for education to his child, or as the case may be, ward between the age of 6 to 14 years. And so we know that as the reflection is already been there in fundamental right. So basically the recommendations, some of the recommendations were not accepted during this discussion. The first is penalty and the punishment for the non-compliance. Now, when we talk about the fundamental duties, we know that we cannot have the penalty or the punishment when the fundamental duties are not followed. Okay, we're talking about the value of the fundamental duty. But in a modern context, you can see that when you read each and every duty so far that we have discussed in the previous slides, you will find that all the duties are almost by the other way around been there as an things that you must do. Without doing that thing, you probably have to face the consequences. So this type of thing is basically a fundamental duties concept will transform in that way, that now we can see that is a more compliance is required nowadays to the fundamental duties. So Parliament may provide for the imposition of such penalty or the punishment as may be considered appropriate for any non-compliance with or refusal to observe any of the duties. So it was one of the recommendations which was not accepted. Another recommendation was that no law imposing penalty, punishment shall called in question. Okay, so no law imposing such penalty or punishment shall be called in question in the court on the ground of infringement of any fundamental rights or the ground of repugnancy to any other provision to the Constitution. So this kind of aspect was also not been accepted by the government. And the third one is duty to pay taxes. So that was also one of the fundamental duty which was recommended to be added in the fundamental duties chapter, but was not accepted so far. Now moving ahead, if you understand the features of the fundamental duties, you will find that what we are discussing is not the fundamental duties. Okay, so we are discussing about the transformation of fundamental duties, the modernization of the law, and basically modernization as a value in context with through the fundamental duties. And so if you understand the features of the fundamental duties, you'll find that basically these are moral duties and the civic duties. Okay, so like cherishing the noble ideas, okay, or like freedom struggle, okay, it's a moral duty, okay, or respecting the constitution, the flag, and the anthem. It is a kind of a civic duty. So all these duties that we can see in the fundamental duties part, we'll find that it is basically the moral civic duties. All these duties has its connection with an Indian tradition, mythology, the religions, practices in the Indian way of life. Okay, so it is nothing new to us. Okay, so that's why we have already accepted the things as a fundamental duty, and we can see the transformation in the fundamental duty, though the traditional practices or the Indian way of life that we are following, and we have kind of a modern structure that we have accepted to that particular tradition. The third important feature that is the fundamental duties of the citizens do not extend to the foreigners, like some fundamental rights they do extend to that. Okay, so this is no basically is our land, and so we are the protector of this particular land. Okay, and so that's why no, we have to take into consideration. That's why we have to protect these particular things as far as our own land is considered. Then the last feature is non-justiciable, like DPSP's Directive Principles of State Policy. So this does not provide the direct enforcement by courts, and so not legal sanction against violation, but the parliament is free to legislate on these particular matters. If you try to understand the criticism of the fundamental duties in the modern context, you'll find that the list which has been provided by the fundamental duties is not exhaustive. Okay, so it does not cover the casting of the vote, paying of the tax, etc. And so, probably to some extent, we may say that the list is not exhaustive. To some extent, it is vague, ambiguous, and difficult to understand because some of the words like noble ideas, culture, scientific temper, they have not been defined. And when any particular part is not been defined, then you are you are free to interpret that in whatever the context that you are interpreting. And so that's why we must have the limitations, or rather, we must have to define the scope of these ideas whenever we talk about the fundamental duties in this noble ideas, culture, and scientific temper context. Then the third criticism is about the non-justiciability, but to some extent that we are saying that these fundamental duties are now being accepted as a part and parcel of the legal provisions. Then we have used the word fundamental, but this performed by the people even though they would not have incorporated. Okay, so that's why there's no use of having the fundamental word, but other way around we are otherwise we are going to follow the duties which have been given in that particular part 4a. Okay, the last criticism about it when we talk about the modernization or transformation of the law since ages, we know that part 4a and not part 3a. Okay, we have added the fundamental duties as a part 4a and not part 3a. Why? Because I'm saying so. It's basically fundamental rights. They're mandatory. No, they are. No, they're the must. Okay, fundamental rights. If there is a kind of an violation of the fundamental rights, you have the remedies. Okay, so that will show you the status of the fundamental rights. At the same time, after that, we have the directive principles, which are not justiciable, and this fundamental duties chapter has been added after the directive principles and not after the fundamental rights. Okay, so probably whether this particular thing or situation has certainly to say something or not, again, is a question. Okay, and you have to find out the answer that whether this was done to lessen down the we can say gravity of that particular duties, or any other reason might be there in having that as in part 4a instead of part 3a. Okay, so this is one of the important element regarding it. But whenever we talk about the significance of the fundamental duties, we know that this reminder is about the duties. Okay, so citizens are conscious about the duties, and so that's why when you say that fundamental duties chapter is there in the constitution, we say that it is there, and so no, we are conscious about following those fundamental duties. It is also a warning against the anti-national and anti-social activities. So basically, the burning of the national flag, destroying the public property, specifically, you can see that as the destruction of the public places, properties, ST buses, state transportation buses. So no, all these things are shall not be there. Okay, and so that's why probably that has its connection with the fundamental duties. Okay, so we shall not no, we shall obey the duties that has been there in the constitution at least. Then the source of inspiration. So basically, fundamental duties in a modern era, it talks about the promotion of the sense of the discipline and the commitment. So basically, the citizens are not mere spectators, but they are active participants. And so this kind of inspiration shall be there. And so that's why we have to focus, we have to value this modernized concept of the duties as well. Then, to determine the constitutional validity of the law, we know that 1992, the Supreme Court said that if the law is in question seeks to give effect to fundamental duty, such law may be considered reasonable under Article 14 and 19. Okay, so again, no, you can very much legislate on the fundamental duties. Okay, and Parliament to some extent can enforce these duties by making the respective laws. Okay, and they have done by different ways in this context. Okay, you can just refer to H.R. Gokhale's statement, the then law minister. I mean, we're talking about the statement which is given at that point of time. He said that in post-independent India, particularly on the eve of emergency in June 75, a section of people showed no anxiety to fulfill their fundamental obligations of respecting the established legal order. So a chapter on fundamental duties was therefore meant to have a sobering effect on these restless spirits who have had a host of anti-national or subversive and unconstitutional agitations. So poem embodying the noble ideas, rhythm, and harmony, as was said by H.R. Gokhale, to the fundamental duties context. Okay. Now, then also the then Prime Minister Indira Gandhi, she said that instead of smoothing rights, inclusion of fundamental duties would help to establish a democratic balance by making the people conscious of their duties equally as they are conscious of their rights. So this is how the importance can be highlighted when it comes to the fundamental duties and the value of fundamental duties. At that point of time, the opposition party strongly opposed the inclusion, but did not make the changes in the fundamental duties when they came in the power. But subsequently, another duty was added by the Atal Bihari Vajpayee government through the 86th Constitutional Amendment Act 2002, calling upon the parents and the guardian to provide opportunities for education of his child, or as the case may be, a ward between the age of 6 and 14 years. Okay, so basically, kind of an consensus that happened in context with the fundamental duties. D.D. Chawla, the concept of fundamental duties, Socialist India, New Delhi, October 23, 1976, he said, the duties may be spelled out in a more concrete form. One is left guessing the noble ideas. To some, even the Bhagat Singh cult may be such an ideal as inspired our national struggle. Again, what is the rich heritage of our composite culture, and what is scientific temper, humanism, and the spirit of inquiry and reform? So the values are beyond the ken of the general run of the people and carry no meaning to them. So basically, he wanted to say that duty should be such and so worded as to catch the imagination of the common man. And so that's why he said that probably to some extent, the wordings might have some loopholes. C.K. Daftari, former Attorney General of India, he said that more than 99.9% of the citizens were law-abiding. And what was the need to tell them to do their duty unless the government thought that they were not doing their duty? So to tell them what their duties are, it implies that they are not content. So if that is the case, after 26 years, it is not their fault. So basically, what is the idea? What he wanted to say is that no, in the absence of the fundamental duties chapter also, there is fundamental duties to be followed by the citizens. If they are not following, it means that they are not contained. Okay, so they are not contained. They don't know it. Okay, so this is how he talked about the fundamental duties. Then we have the Verma Committee observations on the fundamental duties. The committee provided with the provisions like no person can disrespect the national flag, the Constitution of India, and the national anthem under the Prevention of Insult to National Honor Act 1971. So basically, whatever the fundamental duties so far that we have talked about has now been the part and parcel of the law. Okay, so as we said that it was added and it was amended, and then no, we also have some additions after that. And then we also said that the parliament is having the a power to legislate on the fundamental duties. And so far, we have these fundamental duties to various laws being implemented. Various criminal laws have been enacted which provide the punishment to the people who encourage the enmity between the people on the grounds of race, religion, language, etc. We also have the protection of the Civil Rights Act 1955 provided for the punishment in the case of any offense related to caste and religion. We also know that the imputations and the assertions that are prejudicial to the nation's integrity and unity are considered as punishable offenses under the various sections of Indian Penal Code 1816. So basically, in order to prevent a communal organization, we also have the Unlawful Activities Prevention Act 1967, which was there. If the members of the parliament of the state legislature indulge in any kind of the corrupt practices, like asking the votes in the name of the religion, they will be held liable under the Representation of the Peoples Act 1951. So this is also one of the things. Then coming down to the environmental protection, as we know that industrialization and environmental part is also there is a part of modernization and the law. And we know that the Wildlife Protection Act 1972 is there to protect and prohibit the trade in the case of rare and endangered animals. The Forest Conservation Act 1980 was implemented to make sure that Article 51AG was properly implemented. So these are the things that already been considered as has been implemented in the society. Okay. Now, when we talk about the fundamental duties, we know that fundamental duties are always there in there in the society. Okay. So if you consider the natural law theory or the jurisprudence or the legal theory part, then you will realize that no, at all the point, all the time, we can see that no, the duty is being focused more. For example, like we said that as Dharma Shastra, Dharma, where we talked about the laws in the ancient literature. So Dharma is nothing but a duty, as you know. The word itself, it means the duty. And so this is how no, we have started that point of time that no, we have focused more upon the duties than the rights. And so no, till now we also have the same kind of the structure, and we there's a need to have more focus on the fundamental duties. Okay, so we have to value that modernization of the fundamental duties, and accordingly we have to see that whether all the fundamental duties are are fulfilled or not. Okay, so this is one of the important element that I wanted to discuss. Now, coming down to the next important element is about the modernization of the social institutions, basically in context with the family law. Now, when we talk about the family law, yesterday also we have seen that there is a huge transformation in the laws related to the women, related to child, related to domestic violence. And so in a technological aspect also, we have to concern these kind of the rights. So basically, when it comes to the rights of the or the human rights dimensions of the family, because of the prominent legal interest based on the essential human qualities and the urges. They are projected in the context of the family. So the human rights discourse of family law has become an important, rewarding course of an analysis. So we have to do an analysis of that particular aspect. You can have the reference to various articles of the UDHR, that is Universal Declaration of Human Rights, where you can see that the context of the family has been highlighted. Specifically, if you read Article 16(1) of it, you'll find that men and women of full age without any limitations due to race, nationality, or religion have the right to marry and to found a family. Okay. You also have ICCPR, ICSCR, so International Covenants on Social, Economic, and Cultural Rights, 66, and the International Covenant on Civil and Political Rights. You can see that no, these covenants, they reitered these principles and obligated the state parties to ensure the child protection in case of the dissolution of the marriage. Okay, so this is also one of the most important part in context with the transformation of the law on the backdrop of the family as an institution. Then one of the case, Geeta Hariharan case, you might have studied the cases of 1999. Recognizing the mother's equal right in the matter of legal guardianship of the child. The Supreme Court of India relied on the CEDAW Convention in descending the view of the K. Ramaswamy, Justice who was there. No, they have referred the CEDAW Convention and other national instruments to urge the female dependents of the deceased tribal have equal rights to claim the family property. Okay, so this is also one of a kind of when you have the transformation or changes in the laws as per the situation. At the same, we have the changes in the laws. Okay, so that's why we call it as a social transformation. As per the changes, as per the transformation in the society, we keep the laws changing. Okay, so we cannot go ahead of the society. We just have to change according to the society which is in present context. Okay, what they needed accordingly, we just have to provide through the legal mechanism. So it is just not the legislators that they have to amend the laws, but it is through the judiciary where they have to interpret the law in that concern. Then we also have one of the problem with the religion and the cultural dimensions of the family, which is the problem of traditionalism versus modernization. So this is also to be tackled in a better way. We know that the percentage of divorce cases basically in the urban areas is far more than the rural areas. Okay, why it is so? Even you can see that in number of newspapers, you must have seen that the cases of divorce are higher in number, especially if both are working, if the woman is having higher salary, or both are working with an IT professional. So no, these are the things where you can find and you can correlate, and accordingly you can guide yourself how we can tackle this particular kind of a transformation in the society which is taking place. Then we also know that there are huge legislative efforts, especially with the Uniform Civil Code, which is going on. Now, when we have the Uniform Civil Code, when we will have the Uniform Civil Code, probably at that point of time, we may say that no, irrespective of the religion we have, or irrespective of anything, we have commonly some basic principles which will be applicable to everywhere. Okay, so during the making of the Constitution, we know that the overwhelming view was bringing the large-scale reforms in personal laws. But again, we know that UCC would bring the emotional unity and uphold the national image as a progressive society as well. Now we can hope that we'll have such kind of code soon, so that we may say that no, we have uniformly basic principles which will be applicable through the UCC, and it will definitely help to protect the rights of the individuals. So basically, why we have the laws is to have peaceful society. There shall be the tranquility in the society. No, there shall be the protection and the promotion of the human rights in the society. So in that context, we have to think about the UCC. So yeah, uniformity for the sake of the national unity rather than distinctly for promoting the gender justice and non-imposition of UCC upon any unwilling community through the iron hand of law were the major thrusts of the discussion of the Constituent Assembly at that point of time. So basically, the state shall endeavor to secure for the citizens and a uniform civil code through our territory of India, throughout the territory of India, was given in Article 44. So you also have the reference of that article in context with the family law that we are discussing. Okay. Then we also know that there's huge legislative efforts that took place at the backdrop of the family law. So, like at the commencement of the Constitution, family laws had anomalous features. So, permission for the polygamy and the child marriage, prohibition on intercaste marriage and the widow remarriage, absence of divorce, and the other matrimonial remedies, denial of the woman's right to share in the family property or in the property of the deceased person, and the male dominance in the matters like custody, guardianship, adoption of the children caused unjust conditions in overall the social order, uh, specifically the Hindu social order. The Muslim personal law had incorporated still more rigid and unfair usages like polygamy, unilateral divorce, a non-maintenance of the divorced wife, and the gender discrimination in the matters of succession. Even Christian law on the divorce had a rigid provisions. So the then Jawaharlal Nehru regarded that the British policy of non-intervention in the matters of personal law and mechanical interpretation by the judiciary left intact the petrified social rules. So then probably no, we can see that the transformation, true transformation will start in the family laws, basically rationalizing and modernizing the Hindu law, the Mohammedan law, the Christian law, and now we'll probably have the uniform civil code soon to tackle with this such kind of the matters. Then again, I'm not gonna go into details of the Shah Bano and the rest of the cases, as you are well versed about the status of Muslim women since Shah Bano. Then you have the reference to 125 CRPC and the rest of the things, and how it's been changing so far in an, at the legal provision point of view. Then the marriage law, the bigamy, the divorce, and a renewed UCC debate. So all these things have same interaction amongst themselves. And we can have also the reference to the Lily Thomas to some extent when we talk about this context. Now, coming down to the succession of the properties, again, specifically we have the amendments for having the rights of women in the property. Then we have the children's rights and children welfare. It was started considering by the legislative authorities. Then we have various kind of rejuvenating forces that happen at the backdrop. And so that's why probably the law's efforts to support such kind of an atmosphere through the fair principles by blending the tradition and modernity. So both these things wouldn't be possible without the participation of all the people, specifically the reformers, the legislators, the judicial authorities. And so still we can see the changes that is happening to the laws related to the family matters. Okay, so it is just not the divorce, or it's just not the marriage laws, but everything in context with the family law, the maintenance, the custody, the adoption, all the things that it's playing an important role in this context. So the human rights principle and the welfare goals have basically sensitized the process of the transformation. So constitutional orientation to fair personal law system basically is traceable to its major thrust on the social justice and the human dignity. So while the legislative efforts to reform the personal law, so on these lines, had not been supported by the political will and the society's willingness. So the piecemeal reforms did contribute to the legal development that combines the tradition with the modernity. So basically, the true to its activist approach of the social engineering, or we can say the judiciary, has also taken active participation. So that's why probably we call it as an judicial activism. And all these things laid the infusion of the human right values in the welfare scheme and the welfare policies into the family law. So basically, the approach is pragmatic by taking into consideration the aspects of acceptability in an exceptional circumstances as that of the tribal community as well. So the fact that is abstained from issuing the mandate to legislate for enacting UCC shows a kind of inherent difficulty involved. But still, as I said, that we still are working on that particular aspect of the UCC. Okay, so this is also one of the point at the doubts with the concern or in the context of the family law. Now, when it comes to the agricultural reforms, you know that recently the three laws have been taken back by the government in context with the agricultural reforms. Specifically, we have the APMCs, where we have to, we also have to check out what kind of the laws that are pertaining to these kind of the agricultural reforms. Okay, so it is just not the reforms that we have to consider, but we know we have to consider overall development of the agriculture. So basically, if you understand the constitutional approach towards agriculture, you'll find that there are a number of elements which have been included in the constitution, which give effect to have the reforms in context within agriculture. So if you understand the rural sociology of India, you'll find out that it is a huge population which is depending upon the agriculture, and the most of the agricultural part is totally depending upon the weather, the environment, and it is also facing some problem with climatic changes. And so that's why there are huge number of we can say laws which has been there as a part of our society. We can see the reforms that took place. We can see that there are the huge loss. Let us try to understand this kind of a roadmap from we can say debacle to the dreamland of the food security. So basically, we have the National Food Security Act 2013. Before that, we had the laws, like we had the regulation of the agricultural produce market. We have the laws on the warehousing corporations. We have APEDA, that is Agricultural and Processed Food Product Export Development Authority. You can very much go to the website. You can just Google it out. You can just type APEDA. You will find that particular authority and their work. We also have the Agricultural Produce, the Grading and Marketing Act of 1937. Okay, so see, we can see that almost in all we can say phases of the history, we will find the agricultural reforms. And APMC, we can say that.
Hello.
Yes, hello. Yes, Mudasir. Okay, when we have the farm reforms legislation 2020, we know that it has been taken back, and now we have the model of APMC, and then the same model that probably been implemented by the state authorities. So states already have started from then 1996 onwards to have these kind of the system for the agricultural marketing produce. Okay, so this is a kind of an overview that when we talk about the reforms, we have to think about an overall development of an agricultural, we can say, a part. Now we also have its connection with the intellectual property rights, because whenever we have the agricultural reforms, two important things that I shall discuss with you is, one is about the intellectual property and the geographical indication, basically. Then we have its connection with the plant varieties as well, and secondly the rights of the farmer. So basically what happens if the farmers are taking the seeds from any XYZ shop or of XYZ company, and if they're making some kind of permutations, combinations with the crop to have more yield into their field. So whether that kind of thing is going to have the violation of the intellectual property rights of the company or not. So this is also one of the questions that need to be tackled when we talk about the agricultural reforms and modernized era, or liberalization, privatization, and globalization (LPG). So this is the thing that I also wanted to have the reference to. Then coming down to the environmental protection. Now, when we have the environmental protection laws, we know that right to development is also one of the right, and at the same time we have the environmental protection. Okay, so no, we have to have such kind of development which we can call it as sustainable. Okay, so without violating the rights of the future generation, or keeping in mind the limitations, the scope, and the availability of the resources. If you are utilizing these things, then that will help us to have the development with a sustainable approach. We can also know that at a certain point of time, we did not, no, we did not have the laws on the environmental protection. Okay, and then to certain era when we have, we started facing the problems with the climatic change, with the weather conditions that showed us huge changes. And so there from then we started having a kind of an international platform. We had Rio plus 20, Rio plus 10, different kind of the conventions, different kind of the conferences. We still have those kind of COP conferences. And we know that at an international platform also, we're taking care of the environment by making the laws at an international platform, making them mandated to the countries at large. So countries also have to enact the laws pertaining to whatever the laws which has been given by the which has been given at an international platform. You have to implement it in the national laws. Okay, you have to transform that law into the national, and you have to implement accordingly. Then, apart from that, now I also have to discuss about the reforms that have been carried out at different kind of the laws. So specifically, ADR is one of the important aspects when we talk about the reforms in the court processes. Now, when we have the court processes, or basically, if you look to the present procedure adopted by the civil code, it will be noticed that more than 2 crore cases, or rather more than that, these cases are pending as of today. And so this is not a problem only in the in our country, but this is a kind of a worldwide problem that we are facing. So I know, irrespective of the country, so America, Australia, Britain, wherever you go, you can find that no, the huge number of pending cases are there. And so that's why the alternative system needs to be developed. And so when you see the reformation in the civil and the criminal laws, you'll find that the alternative dispute resolution ADR system was basically it came into existence to have more concern about the avoidance of the vexation, expenses, the delays, and the promotion of the idea of access to justice. We have come up with the ADR, alternative dispute resolution system. So in the other words, we can say that ADR system seeks to provide cheap and simple, quick, accessible justice to everyone. So desirability and the necessity of encouraging ADR on the large scale is hardly in dispute, because ADR offers best solution in respect of the commercial disputes of an international character. So basically, ADR techniques are extrajudicial in character, so they can be used in almost all the contentious matters which are capable of being resolved under the law by an agreement between the parties. And so that's why they have been employed with every encouraging results in several categories of the dispute, especially the civil dispute, the commercial, industrial, and family disputes as well. So these techniques have been shown to work across full range of the business dispute banking. And you also know that specifically at an international platform, we have an international commercial arbitration. Okay, so no, the huge we can say expenses, or rather, instead of expenses, we may say that huge fees can be charged at an international platform when you have such kind of skills into the mediation and the conciliation. So basically, contract performance, interpretation, construction of the contract, intellectual property rights, I mean, again, the current and upcoming era, the insurance, the joint ventures, mergers and acquisitions, personal injuries, liabilities, the professional liability, the real estate. So all these things no, are part and parcel of the ADR process, or can be the part and parcel of the ADR process. So ADR procedures basically consist of the negotiations, conciliation, mediation, arbitration, and an array of a hybrid procedure. So it is just not the mediation, but we have number of things now can be included into ADR. Now, when we talk about ADR, it is not intended to, not to supplant altogether the traditional means of resolving the dispute by means of litigation, but it offers only an alternative option to the litigation. Okay, so and that thing that we have to keep into our mind, that there are still a large number of important areas like constitutional law, criminal law, in respect to which there is no substitute of the court decision. Okay, and ADR may not be appropriate for every dispute, even in the other areas. Even if appropriate, it cannot be invoked unless both the parties to dispute are genuinely interested in the settlement. So that's why this is also one of the important, rather gray area we can say about the ADR. Now, when we talk about the difference between ADR and adjudication, we know that in adjudication, we focus more upon the facts, but in ADR, we focus more upon the relationship between the parties. And so that's why I say that those parties who genuinely want to resolve the dispute between them, no, they shall come as a party to the ADR, and then both the parties will agree to have to abide by the process, then only we can have this particular element to be implemented. Then we know that adjudication, it looks about the past. I mean, what happened, and then what things, what facts have been there in the respective case, and then try to the court tries to give or declare something, the rights of an individual or not. But when it talks about ADR, basically, instead of that, it looks with a vision of the future. Okay, so it does not stuck to the past and does not focus more on the past, but sees the future, the futuristic relationship that they are going to probably maintain. So in adjudication, establishment of the liability or the fault can be there. But when it comes to ADR, it basically seeks to restructure the relationship between the parties. So a result is a result in an accommodative resolution. Okay, but in adjudication, we can find it's a winner and the loser. And so that's why ADR is probably preferred when we have an adjudication. So ADR is now booming up because everyone wants peace and a quick remedy, and to have the restructuring of the relations, and to have focus more upon the relationship, and to have quick solutions as well. So a result is in the is in the solution. Okay, but when it comes to the code, basically the result becomes a general rule that this has been there, and according to the decision, that will become a general rule for the society. Okay, but in ADR, it becomes a solution. So solution finding mechanism, we can call it as an alternative dispute resolution. Then in ADR, there's a huge role to be played by the clients and the mediators. In adjudication, it is basically the role of attorneys is the most important part. Now, when we have the ADR, we know that it can be used at any time. I mean, even when a case is pending before a court of law, through recourse to ADR, as soon as the dispute arises, may confirm the maximum advantages to the parties as well. So it can be used to reduce the number of contentious issues between the parties. It also can provide a better solution to dispute more expeditiously and at less cost than the litigation also. So ADR procedures take only a day or a few days to arrive at the settlement. So these programs are flexible and not afflicted with the strict rules of the procedure. So there are huge kind of an rather we can say advantages are there. At an international platform, as I already told you that we have a huge number of the mediation and conciliations you can find. And I mean, the parties, the international platform, they are ready to pay whatever the fees which are required. I mean, whatever the amount they are ready to pay to have the dispute to be settled at an international platform. So that's why, again, one of the booming section of the law is international commercial arbitration. Okay. Then there are different kind of ADR procedures been widely used. Like you have the negotiation. So it is a non-binding procedure in which discussions between the parties are initiated without the intervention of the third party, with the object of arriving to the negotiated settlement of a dispute. So that happens in the negotiation. You also have the conciliation or mediation, where there's a non-binding procedure is followed in which an impartial third party is the conciliation mediator assists the parties to a dispute in reaching the mutually satisfactory and agreed settlement of the dispute. Then you can also have the made-R, okay, so combination of both. So a procedure which combines sequentially the conciliation, mediation, and where the dispute is not settled through the conciliation mediation within a period of time in advance by the parties, then by the arbitration. So that's why made-R. You also have the medola, so a kind of a procedure in which if the parties fail to reach agreement through mediation, a neutral person who may be the original mediator or an arbitrator will select between the final negotiated offers of the parties, and so selection being binding on the parties. So that is the medola. You can also have the mini trial. Again, it is non-binding. You have the arbitration. You have a procedure which in which the dispute is submitted to an arbitral tribunal, which makes a decision. We call it as an award, and that is binding on the parties. And we have separate enactment. We also know that one of the important legislation pertaining to arbitration, mediation, conciliation is pending in the parliament. So soon we'll have again more transformation in the legal principle part in context with the ADR process as well. We also know that there's a fast track arbitration. So like you have the fast track courts, we have the fast track arbitrations as well. Now, one more important point in connection with the ADR is the role of the panchayat system at the grassroots level, which was there. So basically, the self-governance also played an important role in settlement of the dispute. So that's why different kind of the schemes been there, like Tanta Mukti Yojana. So no, we can see that those villages, those do not have any kind of the dispute between the parties, being given the award and given different kind of the schemes by the government. So this is a kind of a promotion of the peace and tranquility within the society at an at a local level as well. Okay. So basically, the panchayat system, it is also an important aspect to be discussed in context with the decentralization of the democratic principles, or basically the self-governance been motivated through this panchayat Raj system. Now, whenever we talk about the arbitration, we know that arbitration to some extent, there is an arbitrator. Basically, the arbitrators are from the judicial background, but the basic understanding of the arbitration is no is no in the context of a growing number of the cases in the court, as also the need to provide the expeditious disposal of the commercial disputes. And so in that context, the Arbitration Conciliation Act is also working. And the court in India also appoint the arbitrators of their choice in certain eventualities. There are also a number of commercial organizations which also provide a format and the institutional base to commercial arbitration and conciliation. Then we also have one of the important elements, that is the Lok Adalat. Now you know that again there's no need to go into details of Lok Adalat, because you already know that the Constitution of India calls upon the state to provide the free legal aid to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. Uh, it was a discharge of this obligation that the Committee for Implementing Legal Aid Schemes, so CILAS, so CILAS, Committee for Implementing Legal Aid Schemes, was established in 1980, and they have initiated the non for ML for known as Lok Adalat. So Lok Adalat, which means a people's court. A court in its accepted connotation. So basically, it is a forum where voluntary efforts aimed at bringing about the settlement of dispute between the parties are made through the conciliatory panel and persuasive efforts of the Lok Adalat. They provide a kind of a speedy and inexpensive justice in both rural and urban areas. Okay, so you can very much see that the courts, maybe the high court, or maybe the irrespective of the areas, you can find that there are different kind of the Saturday has been allotted to have the Lok Adalats, Mahalok Adalats in context within Maharashtra. You must have seen that the disputes which has already been settled or which are about to get settled is bring that we have to bring it before the panel, and then we have to settle that particular dispute through the Lok Adalats. And so that's why basically the people's court, that's why we are saying to this particular aspect. Then we have different kind of the parliamentary machineries. We have the legal provisions of the area to some extent. We have the other alternative dispute resolution system. For example, you must have heard these words like Lokpal and Lokayukta. You must have heard the domestic tribunals, Nyay Panchayats, Gram Panchayat. You have the Consumer Protection Act, and accordingly you have the forums for the consumer protection, so the consumer courts. You also have the labor court. You have the in-house arbitration, standing committees, you have the family courts, green tribunal, cat, mat. So all these are, no, we can say the specialized agencies, so that we can have we can have the resolution of the matters as soon as possible. So it is just not that no, we have the area, but at the same time we must have these particular uh, no context of the area. Now, there is one more important point about the confrontation versus consensus. Okay, so you can also find it in the in your syllabus, I guess. Okay, yeah, it's there, confrontation and consensus. So, what is confrontation? So, it is basically it is nothing but an adjudication, and what is consensus? It means to settle the issue with mutual understanding by any of the ADR methods. Okay, so confrontation is adjudication, and consensus is settling the dispute with the consent. Okay, so there are various ADR methods which are discussed so far till now, and no, whatever may be the process to be followed, you can very much have that particular process, and accordingly, you can have either the confrontation or the consensus. Okay. So this is one of the point that I wanted to talk about. Just a minute. Okay. Now, coming down to the last point for today's discussion is about the reforms in context with the prison. Okay. Now we know that we have the huge number of cases, number of prisoners, or rather we will say under trial prisoners. We can find it into the jail, and all the jails, the prisons are filled fully, or rather we will say beyond the limit, and that is going to have a kind of a bad impact not only on a kind of an administration of justice system, but an overall a perspective to society. Because recently, the one important point that is coming out is about the health of the prisoners as well. Okay, so it is just not that we see the culprit or the offender is born as a criminal, but the situation makes him to do that particular thing. Okay, and so that's why we say that their rights shall also to be focused when you understand them as a human being, then only probably we can have the better opportunities from them for them as well. Now, whenever we talk about the prison reforms, it is just not the prison reform that is about the administration that we have to focus, but overall reformative theory that you must have talked about in this concern in your theories of the punishment. And there, you have seen that yes, deterrence is important, that in the heinous crimes, we must have the deterrence theory to be implemented. But at the same time, we must have to talk about the reformation to be carried out into the life of those particular individuals. One more important element that I wanted to discuss about it is the social transformation in context with the prison reforms. Okay, so if you just find it out on the ministry's website, you will see that there are a number of enactments, rules, and regulations which talk about the prison reforms. Okay, so prisons or the persons detained therein is a state subject under entry 4 of the list 2 of the 7th schedule, you already know in the constitution. And the administration, the management of the prisons is the responsibility of the respective state governments. However, Ministry of the Home Affairs provides regular guidance and advice to the states and UTs on the various issues concerning the prisons and the prison inmates. So we have the Prison Act, we have the Transfer of Prisoners Act 1950, we have the Repatriation of the Prisoners Act of 2003, we have the Repatriation of the Prisoners Rule 2004, the Model Prison Manual is there in 2016. And apart from that, we know that there's a huge list which provides the guideline in strengthening the security arrangements in the jail, in facilitating the children, providing the facilities to the children of women prisoners, tightening the security measures in the jail, sensitization of the prison inmates, detention of mentally ill under trial prisoners, basically ban on smoking, transfer of prisoner from one jail to another jail, use of mobile phones, overcrowding of the prison. So on all these matters are specifically, as we are the master students, you must know that 436A of CRPC to reduce overcrowding of the prison, 433A of CRPC, which has a restriction on the powers of remission on or the commutation in certain cases. You can also see the guidelines for the safeguarding the interest of the death row convicts, judicial custodies of reckoning half life spent in the judicial custodies of these people. So identification of the visitors, the linking of the accounts, providing them suitable work for them. So all these things are there. At an international platform, you also know that there are UNODC Nelson Mandela rules for those kind of the reforms. You also have the NHRC, National Human Rights Commission, who is also working on the reforms of the prison. We have different kind of the commission reports and the law committee report on the welfare of the people at large, so they can have sound, at least basic needs must be fulfilled in the prison. Now, one may say that why we need to have reforms in the prison administration. So prison administration must think about the prison administration, not the rights of the prisoners. Okay, but again, it is not like that. As we have said that we have to think more upon the correctional services rather than the deterrent things that we usually follow, because again, the same thing that no one is born as a criminal, and so that's why we have to take into consideration all these people in that particular same context. Okay, so I think that's it from my side so far. I'll just have a quick revision of whatever that we have talked about. So we have started about just a minute. Yes. So we have started about talking about the value of it, and value of the rather modernization as a value, and then we have talked about the constitutional perspective of the fundamental duties. We have said that how the fundamental duties been there in the constitution, and then the transformation of the fundamental duties from the constitution to implementation of fundamental duties through the legislative mechanism so far, implementation through the laws made by the parliament. Then we have talked about the modernization of the social institutions with reference to the family law, how the families have been changing, how the rights of the individuals been changing, special reference to women and child that we have seen. Yesterday also we have referred the same. We also have seen that a path towards UCC, why it is important, what are the significances of having the UCC. Then we have talked about the agricultural reforms and the agricultural agrarian reforms, agricultural reforms, where we have talked about the continuous development in the legal perspectives as well when we have the agricultural. Basically, though we have taken back, the government has taken back the law on the agricultural reforms, but still we have the model law, and already most of the states have already implemented that a model law, APMC, Utpanna Bazar Samiti असं ज्याला आपण म्हणतो, कृषी उत्पन्न बाजार समिती. So we also have that. Then we have talked about the environmental protection. We have referred the directive principles. We have referred fundamental duties, and then we have referred right to development vis-a-vis sustainable development. Then we have talked about the modernization of law, specifically alternative dispute resolution system, confrontation and consensus conciliations, lok adalats, democratic decentralizations, the local self-governance, basically. Then we have also had the prison reforms, and we have talked about it is just not the prison reforms which are essential, but at the same time we also have to think about the human rights of those who are there in the system. Okay. So that's it from my side on your module 4 of modernization and the law. So thank you for your patient hearing. I'm not going to bore anymore. So I think that is enough for the revision. You can very much refer to some of the important books. Specifically, you can go for Ishwar Bhatt's book on law and social transformation in India. You can also refer to various articles, and you just have to make it sure that you can also have reference to the research articles which are talking about the current trends into law. Okay, so it is just not that the thing that we have to consider is from examination point of view, but at the same time we have to consider it from a knowledge point of view, because at every point of time we are going to deal with the matters. Okay, and so we don't know that what kind of matters that will be there before us, and so accordingly we have to develop or inculcate the skills into it. The main objective of having the social transformation for master level is that you must know that how the law has been reformed, and how you have to develop yourself to tackle the futuristic problems, and to develop yourself to have your more intrinsic interpretative skills, and then accordingly you can go ahead with the futuristic approach. Okay, so that's it from my side. If you have any doubt, you can just put the question in the chat window, or can unmute and can ask. I'll just keep this meeting on for next 1 minute. Thank you all.
सर पुन्हा एकदा सांगा ना त्या पुस्तकांची नाव तुम्ही जे आता सांगितलं ते.
ईश्वर भट्ट आहे सोशल ट्रान्सफॉर्मेशन, सोशल ट्रान्सफॉर्मेशन इन इंडिया असं नाव असावं त्याचं, ईश्वर भट्ट. You can refer to those books. You can just Google the respective we can say the commissions or the committees. Okay, so for example, if I say women, the Commission on Women, you can very much go to the National Commission for Women. In the same manner, we have the Commission for Child. We have NHRC. You can very much refer to those things. You can also have the reference to the intellectual property rights. It is must, because an upcoming thing that we must talk when we talk about the social transformation.
Okay, thank you.
Okay, so that's it. It was a great pleasure in talking with you, and giving a little bit knowledge and a kind of a revision to the social transformation, specifically that those two modules. Hope to see you soon, and hope to see you physically instead of online mode. Thank you, everyone. Have a great day ahead.
Thank you.
Thank you so much, sir. Thank you so much.
Thank you, sir.
Thank you very much, sir.
Sure.